Okay, so we know what hearsay is. Hearsay is an out-of-court statement offered for the truth of the matter asserted. And we know that it is essentially a declarative statement, so not a question, right? A question is not going to be hearsay. But if it's a declarative statement, right, the car was red, the light was green, whatever, and that statement was made out of court, then it's hearsay, and thus baseline rule is inadmissible. Now what I'm going to give you are some instances of things that are not questions, but are also not hearsay. So this, what I'm about to tell you, these are not hearsay. They're not hearsay exceptions. Do not confuse these with hearsay exceptions. This is just non-hearsay. So number one is going to be words of offer and acceptance, right? So if we have words of offer or acceptance, that is not hearsay, right? Because those words have a legal significance of their own, right? In terms of forming a contract. So the point is words of offer and acceptance are not hearsay. Also, anything that is libel or slander, right? Again, in a defamation case, because the words themselves, the defamatory statement, the fact of it existing, the fact that I made the defamatory statement, regardless of whether or not it's true, the fact that I made it is significant. And so again, just like words of offer and acceptance, libel and slander, those defamatory statements, that is not going to be hearsay. And then finally, anything else that goes to show motive or notice, right? Motive or notice. And this is what we want to be aware of. So motive is pretty straightforward. If I'm talking about why I'm doing something, then again, it's not hearsay. And it doesn't have to just be like my statement, me as the witness talking about a prior statement that I made. It could be a statement that I heard someone else make, but if it was a statement about motive, if it goes to that person's motive and that person's motive is relevant to the case, it's something that is relevant for the jury to hear, can I testify about that statement if it goes to their motive? Yes. If it goes to show notice, right? That the fact that, I told you that, the seatbelt on the ride wasn't shutting properly, right? And I told you on Tuesday, and there was an accident on Friday, right? Regardless of whether or not the thing was actually broken on Tuesday, what matters is I told you on Tuesday the thing's broken. So you were on notice as of Tuesday that you should probably go look at the seatbelt thing, right? So that's the point, is it's not being offered for its truth. It is independent. It's going to show motive or notice. So again, what is not hearsay? Offer, acceptance, libel, slander, any other independent acts, words, whatever, that go to show motive or notice. And so if you see one of those, then it's not hearsay, it's admissible, it's substantive evidence. Otherwise, we're going to say that if we're not fitting into one of the exceptions that we're about to talk about, what is the answer choice that we're looking for when we know we're doing a hearsay question? We're looking for inadmissible as hearsay, not within any exception. That is going to be our, I hate to say default answer, but that is the rule, is that hearsay is inadmissible. And the reason why I do it like this and emphasize it like this is because it is far better to err on the side of hearsay, not within any exception, than to think, oh, you know what, this looks like the dying declaration. This looks like the present sense impression. I'm going to go ahead and pick that because I see some of the elements of excited utterance. No, you must make sure that every single element of that hearsay exception is present in the facts, because I am telling you, this is how they test hearsay. This is how it's tested. They give you facts, there's an exception, and they take one of the elements away, or they leave them all there, right? And so it's fair, right? Because either you know the exception cold, you know all the elements of the exception, or you don't. And so there's no argument to be had. And again, if they give you facts that are ever kind of in the gray area, I kind of feel like I should be writing an essay about this, look down into the answer choices at that point, because then you can identify, oh, okay, this is what they're testing me on. They're testing me on this borderline case with this exception. There's only going to be one answer choice, I promise you, that talks about the thing that you're saying I should be writing an essay about this. That'll make more sense when we start to look at some actual questions. You'll see what I mean. But again, the main takeaway from this point, do not pick an exception. Don't assume an exception applies unless you are 1000% certain that each and every element of that exception, as defined in the rule book, right, the federal rules, is present in the case. So now we can talk about the hearsay exceptions. All right, hearsay exceptions. Let's get into it. We have, first of all, the present sense impression. Now, the present sense impression, this is pretty straightforward. This is a statement of fact, right? Not an opinion, right? But it's a statement of fact that I am making while I'm observing whatever it is that I'm talking about. And I'll say that last part again because it is critically important. It's a statement of fact that's made while I am observing whatever it is that I'm talking about. So if I am on the phone with my wife and she's just like, hey, what's going on? And I'm like, oh, I'm just walking down the street. I see this guy in a blue hat and he just crossed the street, right? I'm just talking. I'm observing something and I'm relaying that information. I'm making the statement as I am observing it. How is this going to be tested? They will give you what looks like a present sense impression. They will give you what looks exactly like what I just talked about. I'm telling my wife that I saw the man in a blue hat, or the man in the yellow hat, I think is the Curious George. So the man in the yellow hat was walking across the street. If I am telling that to my wife when I get home, an hour and a half later, am I at that point describing it as I'm seeing it? No. And so is it a present sense impression? No. Do you see how you have to be just specific? You have to be so focused on each element, because it can look, and again, it can look the exact same. When am I saying it? Am I saying it as I'm observing it? If I said it as I'm observing it, present sense impression. That's important. Now we move to another one that gets confused with the present sense impression, and this is the excited utterance. Now, the excited utterance, what makes it different from the present sense impression is the emotion, the excitement, right? The present sense impression is just the statement of fact, right? The present sense impression is the observation that I make while I'm observing it. The excited utterance is a statement that I make about a startling event, condition, experience, whatever, that I'm making while I am under the stress, the influence, the impact of that event. So I'm on the phone with my wife, and God forbid I'm watching in front of me and I see a car accident. And I say, oh my God, I just saw this terrible car accident. I saw this startling event and I am affected by it. I'm still under the influence or the effect of that event, right? I'm still feeling the stress of that, and so I am relaying that. The point, what makes the excited utterance different, again, aside from the emotion, is that there's a little bit more malleable time frame in terms of when the person can be saying it. Now, a couple of different ways that you're going to see this tested. First and foremost, if I give you this same fact pattern two different ways, and in one of them I'm just relaying the information and there's a period at the end, and in the other one it says Bob yelled or Bob screamed and there's an exclamation point at the end of my quote, and answer choice A says present sense impression and answer choice D says excited utterance, which one are you going to pick if I screamed and yelled? You're going to pick the excited utterance. right? If they tell you words like screamed, yelled, whatever, if they tell you that I'm under the stress of whatever that event is, they're saying that that meets the criteria for a excited utterance. They give you the exclamation point. That is a signal that we're talking about an excited utterance and not a present sense impression, because the present sense impression is not talking about the emotion, right? The present sense impression was focused solely on what I'm seeing. I'm saying what I'm seeing as I'm seeing it. Excited utterance is more about, I had this startling event, this traumatic event, and I'm still under the stress, I'm still under the strain of that event when I'm making whatever statement I'm making. So it could be even potentially a day later, maybe a few days later, depending on the situation. But again, those cases where it's like, hey, when does the excitement end? When does that abate and we move into the here's? That's great stuff. That's the argumentation. That's the essay. That's what we got to avoid on multiple choice. We don't get into that type of thinking on multiple choice. On multiple choice, it's going to either be obvious, I'm still under the stress of the event, or it's 6 months or 6 years later, and I'm certainly not still under the current stress of that event. Or maybe sometimes they give you the gray area one where it's like the next day and who knows. In that case, they will give you only one answer choice talking about a present sense impression, and it's going to talk about the specific element of time, whether or not enough time had passed that you weren't under the stress of that event, something like that. Or they will give it to you like, which of the following hearsay exceptions would be the best argument for that party, something like that. And it'll be excited utterance and then 3 other garbage answers, business records, dying declaration, and some other one that doesn't make sense. They'll have some language to make them look kind of somewhat attractive, and you'll second guess yourself because it's like, oh, enough time has passed. It's not really an excited utterance. No. Recognize from the facts what they are telling you. What are they asking you about? And if they are giving you a situation like that where it's close, maybe it could be an excited utterance. And then you look down at the answer choices and the other ones are talking about nothing having to do with the fact pattern. And there's one answer that is talking about the element of time vis-a-vis an excited utterance. That's the answer choice I'm going to pick. On to the next question. All right, and then next up we have the third one that really gets confused. All 3 of these get confused together, right? The third one is the then existing mental, emotional, or physical state of mind, right? So sometimes this is just shortened. We kind of sloppily refer to this as a state of mind exception, right? But the technical definition, what are we talking about here? We are talking about a then existing, so what was the state of mind when the statement was made, when the assertive conduct was done, if we're talking about a non-verbal hearsay, right? When the thing happened, typically think statement, when the statement was made, what was the then existing mental, emotional, or physical state of the declarant, right? And who's the declarant? Just the person who makes the hearsay statement. So that person, right, if they are saying either, so we can kind of break down what this is. If that person is talking about their motive, right, if they're saying, I'm doing this because I love my kids so much, right, or I'm doing this because I hate this person so much, right, if we have a statement that is about their state of mind where their intent is. If we have a statement about the other way that intent, that's kind of more motive, right? The other way that intent, or what is sometimes referred to as future intent, is worked in here, is where I say to you, after I get done recording this video, I am going to go to the store. That statement, that's what I'm going to do in the future, if I'm making that statement, then that statement about what I'm going to do in the future, that is going to be admissible as a statement of my future intent. Again, it doesn't mean that I actually went and did that thing. It just means that at that time, I made that statement that was reflective of what my intent was. In other words, we're gonna take the person's statement of intent for this purpose, for this exception, at face value, and we're gonna say, okay, if that's what the person said they were intending to do, then we're going to say, okay, that counts as the state of mind exception, right? Then existing mental, emotional, physical state. When we talk about physical state, this is the things like pain, right? If I'm telling you about the pain that I'm in. Now, I don't want to get confused with that other piece about medical treatment or diagnosis, but understand that this is where the line gets drawn in some of these questions, right? If I tell my friend that I am in pain, and my friend has no medical training, there's no experience, there's no facts that would indicate that I'm seeking any type of treatment or diagnosis. And my two choices, answer choice A is statement made for the purposes of medical diagnosis or treatment, and answer choice D is then existing mental, emotional, or physical state. You can see in that case, we're going to choose then existing mental, emotional, or physical state because that's the most specific answer to what the facts are talking about. And so the whole deal about, well, where does the line get drawn in terms of a statement made for medical purposes versus these other hearsay exceptions, we don't need to get into that because they are going to be very clear. The question is testing me on this element, either this definition, either all the elements are met or one of them is not met. They're giving me multiple different hearsay exceptions, but only one hearsay exception that they're giving me is going to apply. But those first three, if you can keep those first three distinguishable from one another and know what each one looks like, you are off to a massively great start in terms of hearsay. So then a nice next one to talk about, because we kind of alluded to it with the then existing mental, emotional, or physical state where we talked about the pain thing. We also have the statement that is made for the purposes of medical diagnosis or treatment. Now, does this have to be made to a particular level of healthcare provider? No. But the idea is, what's my intent in making the statement? I'm making the statement for diagnosis or treatment. So there has to be some indicia where I believe that I'm seeking medical attention, right? And they're going to make that obvious from the facts, right? So you're going to know that piece. Here is the trickier piece in terms of where this gets tested. The statement that I'm making has to be about what I'm being treated for right now. This existing wound could be the circumstances for how I got it, right? And what brought me to this predicament. But if I then also start talking about other crimes that I committed years and years ago while I'm in this setting, getting medical treatment or diagnosis, if I'm just making these other statements, those are not going to fall within this exception, right? The idea is the statement made for medical diagnosis or treatment has to be about that thing in order to be admissible under this exception. So if I'm talking about the reason why I am having whatever symptom I'm having, and I'm doing that in order to get treatment for it, then we're going to say that statement meets the exception statement for diagnosis or treatment. The next two that we get into are the business record and the public record. And they can get confused, but hopefully not, because they're pretty straightforward. Okay, the business record is a great example of where they can make it look like we have a business record exception, but it does not qualify, right? We know that if it's done we know that if we have this, whatever the record is, the transaction log, or whatever record is being created by the business, it's easy to look and see that the business created the document and think, oh yeah, business records, right? But the business record that's in question, if it's going to be admissible as a business record, it has to be done all the time, every day, routinely, as a matter of course, right? It's not something that is done for a particular incident or instance or case, right? So a great example, we got the supermarket slip and fall deal, and after a customer falls, the store writes up an incident report based on that incident. Is that report going to be admissible under the business records exception? No, because they don't make that report all the time, every day, as a matter of routine practice. What you're looking for is a matter of routine practice. So does it have to be every day? Well, no, in the sense that like your quarterly sales report isn't available every day, but every quarter that report is generated, right? The idea is it is done routinely. It is done as a matter of course. Now, once that record is authenticated, and remember we talked about authentication in another chapter, but the business record is authenticated, and typically that's going to be by someone who's a custodian of the record. That's just the legal term for the person who actually manages that system, actually manages that file, actually can explain, okay, this is what this chart of data that we're looking at is. You have to have somebody come in and explain it. You can't just show the jury the cell records. You have to have somebody from AT&T or Verizon come and say, yep, these are the cell records. But once they do that, once the records are authenticated, if they are done all the time in the regular course of business, then they are going to be admissible. Okay, so just to kind of recap business records, what is the main takeaway there? What's the number one thing we're looking for is the routineness, right? Is this something the business does all the time, as a matter of course, right? Contrast that now with the public record, where with the public record, what we're really looking for is this an official statement of an office or agency, right? So we're going to see something like it has either an actual seal on it or it has some other marking, some other identification that shows this is the official report from the tax assessor, right? In other words, we have to see, just like with the business records, that this is authentic, right? That this is an authenticated record. Now, I don't want to get too hung up on that because typically in these questions, if you're doing a question that's going to be testing you on the public records exception, they're going to make it pretty clear that it either is or isn't that public record, right? So, but just to make sure we're understanding, this isn't just like a note that the comptroller wrote, in their notebook necessarily. This is an actual official publication, right? Something that is being put out for some type of dissemination by a public office or agency. So that's the first part of it, is an official statement made by that agency. Or it can also be a statement that's made, in that report by someone under a duty to report as a result of their employment by a particular office or agency, right? So in the cases where we see it's an individual who has a duty to report, then what they say in that statement, their contribution, right? Their contribution to the record there, that would be admissible. So the example that comes to my mind would be like the fire marshal's report, right? After there's a fire, the fire marshal goes out and they assess and will cause the fire, all that stuff. That report that then gets generated, that report is incident specific. So keep that separate from the business record, right? Because when you're talking business records, remember that one, if I wrote up a report for a specific incident, that wasn't going to be admissible under business records, because remember, that's not something that's happening all the time as a matter of course. Here, this is different, right? This public record, if there is, and this is something that you don't have to get into this specifics, right? This is taken for given, but there's a statute somewhere that says that this is how this fire department's going to operate, right? And so the bottom line is that there's a law that's going to require their reporting in a particular way, right? They have to do the report of, with the fires and different stuff. The point is that in addition to that, the person who's actually the inspector, the fire marshal, the firefighter, whoever's out there doing the inspection, their comments, their assessment in the report, because they're under a duty to report, right? What they have to be truthful in that report. that's going to be admissible as part of the public record. Now let's talk about how this gets tested, and you can see where this would maybe get a little bit confusing. Let's say the inspector, the fire chief person goes out there and they are inspecting and they talk to me. And I say, yep, I saw Joe playing with matches over by the shed over there. My statement that I, Bob, saw Joe playing with matches over by the shed there, is that going to be admissible as part of the public records exception? No, it's not. It's not going to be admissible under that piece of the exception. Right now, there may be other instances, other times that statement could come in via another hearsay exception, but remember, that's not what we're talking about here. And the question is this fact pattern as I've laid it out here. So we have the inspector, and then we have somebody making a statement to the inspector about what that other person saw. That statement from the bystander, that bystander is not under a duty to report, and so the bystander's statement is going to be hearsay, right? The bystander's statement is not admissible as part of that public record. So that's what we want to understand. The public records exception itself, what does it cover? It covers the statement by the office or agency, right? A public office or agency, or a statement made by someone who's under a duty to report to a public office or agency. So that's public records. It will look pretty identifiable, right? Pretty much it should be there for you. But again, we just want to make sure to look out for that wrinkle where we might have other people who don't have a duty to report making statements, and we'd have to have an independent hearsay exception for those statements to come in. Doesn't mean they're, as a matter of course, inadmissible, but it does mean that they would not be admissible under this particular exception. And that's why it's so important to keep each of these exceptions different. Because even though it's admissible, if you were to say it's admissible as part of the public record, that would be wrong. Now, the next piece here is the absence of a business record or the absence of a public record. And so all this is just the negative inference that occurs when something's not there, right? So I'll give you an example, right? If I say I have a driver's license, but they can go in the DMV, the RMV records, right? And they bring on the person who is the custodian of those records, right? Somebody that works at the RMV. And that person can pull up they can search all the RMV data for, the state, and my name's not in there. My driver's license isn't in there. So in that case, the absence of that public record there is going to show, it's probative of the fact that I don't actually have a driver's license in that state, right? And so that's the idea there. It's like if we would expect there to be a record there, we would expect there to be a particular deal, and there's not. So like in the business records thing, we would expect a company to file some type of financial statements, right? They were to keep some type of records. And if they just weren't keeping records, right, that could certainly be admissible, right? Now, that wouldn't be admissible in every case, right? That would still have to be, again, a relevant point, right? That would have to go to something that's material and probative. But the point is here, there's an inference that can be drawn in the absence of these records, just as much as we can look at what the actual record is and get some conclusions from that. So that's pretty straightforward, and there's not a whole lot that we want to get tripped up on with that. Just again, understand it can go kind of either way, and it is a separate hearsay exception. So we had business records, right? This is got to be done routine practice. They have to be authentic. Usually that's the custodian of the records coming in and talking about them, right? Then we had the public record, the official statement of the office or agency. We look for the seal. We look for some type of thing that says this is the official document. And remember, this also encompasses the people who have a duty to report to that office or agency, right? So if they're under a legal duty to report, a police officer is another example, right? I think anybody that is going to be working for, again, the public office or agency, their statements, their assessments, that's going to be admissible as part of the record. The other stuff would have to have an independent exception for. And then just remember there's this other piece, which is the absence of a business record or the absence of a public record, that absence is itself another hearsay exception. All right, so that is that piece. We are moving on now to the next set of hearsay exceptions. All right, so cruising on with our hearsay exceptions, the next one we have is the recorded recollection. Recorded recollection. Now, this one gets very often confused with something that we talked about in a different section, right, back when we talked in the very beginning about the presentation of evidence. And remember, there's that rule about refreshing a witness's recollection. So what's common in those terms is the recollection. And all we mean when we're saying recollection is just the witness's memory, right? How can a witness recall it? So let's look at the other two words that we have there. And the other thing that we talked about refreshing, that there's a refreshing recollection. And in in this one here, we're talking about the recorded recollection. Now, what's important here, and I talk about this in some of the other stuff that I do, and talk about how to read an MBE question and why it's really important to pay such close attention to every single word, each sentence, and how the words in the sentence are functioning. I want to kind of just spend a minute on this point because I think it'll kind of make it a little more clear. We think about the refreshing recollection, to refresh a witness's recollection. What is refreshing there? That's a verb. That's something that we're doing for the witness, to the witness, with the witness, to help them, right? We are refreshing their recollection. And remember, with that one, we said that anything can be used to refresh the witness's recollection. There are some rules around that. Now, I'll go back over those in a second. But just understand, what is the word refreshing doing there? It's refreshing. It's a verb. Contrast that now with this part in the hearsay rules, right, where we talk about the recorded recollection. Okay, what is recorded there? Recorded, in this sense, this is an adjective, right? This is describing, this is modifying, right, to get really, back to our English major days, right? Maybe even before that, I guess. But the point is that the word here, recorded, is not a verb. We're not presently recording a recollection. It is a prior, it's a recorded recollection. It's something that happened in the past. So right away there, that should help us differentiate between which one fits within the hearsay exceptions and which one doesn't. Because remember, hearsay, this is out of court stuff, out of court statements, right? Stuff that already happened in the past that's now being brought into court for its truth, right? For whatever the contents of what it's saying. And so the fact that it's already recorded in the past is indicative of the fact that it's going to be something to do with hearsay, right? Versus if we are going to refresh, if we're in the process of refreshing a witness's recollection, that's something we're doing right now. So let's take an even deeper dive and understand how these two things are different. Because I think if we can keep these straight, this will clear up, not only will this clear up some confusion around hearsay stuff, but you begin to see how they can take two things that sound really similar, put them as answer choice A and answer choice B, and when we first encounter these questions, you sit there, you don't know what to do because we don't have a good way of keeping these terms that sound similar separate. And even though they're talking about two totally different things, they can look like attractive answers to the same question if we don't understand how to keep them separate. If we understand what they are separately, then we understand, okay, well, if we're talking about a hearsay thing, then we're not going to pick the answer that talks about a recollection refreshed or refreshing a recollection, and vice versa. If we're talking about putting something in front of the witness presently right now, it's not going to be that recorded recollection exception. So how do these actually work? Let's quickly recap on the refreshing the recollection, the verb, the thing that's not hearsay, it's not a hearsay exception, not what we're talking about now. I'm just going to touch on that briefly, and then we'll get back into the actual hearsay exception. So this is a little bit of just a quick recap. What are we doing when we're refreshing the witness's recollection? The witness says, hey, I can't remember. And you can put anything in front of the witness, show the witness anything that will help them remember, and then they're able to testify from their memory. So they're not reading aloud from whatever you're showing them. You're going to show them a copy of the deposition. They can look at the copy of the deposition. They can read the question. They can read the answer that they gave then. Oh, okay, I see. I understand what answer you, the attorney who's asking the questions, are looking for me to give you now. I can, yes, my recollection's refreshed, close the deposition, put it aside, and then testify from memory. And that's the key, right? In that instance, what is being used to refresh the witness's memory, no one but the witness is seeing or hearing that, right? The jury's not going to see it. The jury's not going to hear it. And honestly, in federal court, there's not even a rule that says the other side has to see what you're using to refresh the witness's recollection with. And there are bar questions about that, so just kind of a small note. Here's the bigger point, though. The refreshing of a witness's memory, all it is doing is it's serving to give that witness a chance to look at their notes, right? To check their notes and then testify from memory. And that's all refreshing a recollection is. And the rule is just basically that anything can be used to refresh, but it's not going to be received in evidence. It's not going to be read into evidence. And the other side doesn't have to see that. Now, contrast that with the hearsay exception we're going to talk about, which is the prior recorded recollection, right? The recorded recollection. Now, a recorded recollection, the biggest thing that makes this different from to refresh a witness's memory, right? That thing that we just talked about. Here we're talking about, again, a statement, something, whatever the words are that are going to be coming in, those have already been said. That's already been made. The statement that is going to be coming in as a recorded recollection exception to the rule against hearsay. The way that works, the way we identify that is the statement, the thing that the witness is going to say is not going to be coming from their memory right now, but they're actually going to be reading it off of the page. They're actually going to be reading that recorded recollection. So what's the next key with this? Well, the next key is that it has to be a statement that the witness themselves either wrote or adopted, expressed some familiarity with in the past, right? So the witness, this has to be like their own statement, or even if they didn't write it, one that they adopted previously. And so adopted just being like, yes, I agree with this. This is what happened. I assent to this statement, right? You kind of get the idea. And now probably the biggest thing is that unlike where we just put something in front of the witness to refresh that recollection, here we're going to let the witness actually read what it says on the paper. Now, the jury's not going to receive it in evidence physically. The jury's not going to get the document, but that recorded recollection, so what I said on this previous time, if it's my statement and I at that point knew this to be true, and I'll explain this a little bit more in a second, but if it's my own statement and I previously had adopted it, and now my memory is in question. It's been shown that I can't remember whatever it was that I knew about at one time. And I knew about it at one time, and when I knew about it, when that information was fresh in my mind, I wrote it down. And that's the recorded recollection that now we want to bring in so I can read. It's kind of like the diary, right? So I can read what my recollection was at that time, right? When did I record it? I recorded it when the events were fresh in my mind. And now I'm on the stand as a witness. And this is very important. There has to be a showing that the witness's memory is in doubt. So in other words, if I go to take the stand to testify and there's no showing that I don't remember something, and they want to ask me what happened last Tuesday. And so if the if my attorney wants to, instead of first asking me, okay, Bob, can you tell the jury what happened last Tuesday? They just say, okay, Bob, now I'm going to give you a copy of your diary and I'm going to have you read to the jury what happened last Tuesday. Well, there's been no showing that my memory about what happened is exhausted, is that I'm unable to remember it. It's in question or in doubt. There's been no showing of that, right? Now, it's really easy for there to be a showing of that. I would just have to say as the witness, I don't remember. And then, there's maybe in real life a few more steps to get to all the way to lay the foundation for a proper recorded recollection to come in. But again, they're going to make this clear. When you're looking at this on an MBE question, they will either have the witness's memory be in doubt, or that's sometimes the element that they take out. They give you everything else that makes it look like it's a recorded recollection, but there's been nothing to suggest that the witness doesn't remember what they're now wanting to bring in this other document to testify about. Remember that we don't want the old stuff coming in. We don't want what you said in the past, what you wrote in the past. We want you to testify live to us now. We want you to answer the attorney's question. If the attorney asks you a question as the witness and you're like, I don't remember this, but at one time this information was fresh in my mind, and at that point when the information was fresh in my mind, I wrote it down, okay, then we can take that recorded recollection and we can have you read from that recorded recollection to the jury. Right, the jury's not going to get that recorded recollection. They're not going to physically receive it, but they are going to be able to hear word for word what you recorded prior, right? What the recorded recollection is. And so that's the overall idea, right? So remember, we have to refresh the witness's memory. We're going to put anything in front of them, jog the memory. Yep, okay, I remember this now. I can testify from memory. Versus completely separate from and different from this hearsay exception, which is the recorded recollection, the recollection which previously had been recorded. That's what we're going to read into evidence. If you can keep those separate, you are ahead of like 80% of people who are going to be going to take the bar, because this is not easy stuff. If you can keep those separate, you've got some points that a lot of people are going to struggle to pick up. Anyway, I'm pressing on with our hearsay exceptions. Let's get into this next set here. All right, so next up then we've got the learned treatise exception. Now the learned treatise, this is hopefully pretty straightforward in the sense that all the learned treatise is something that an expert witness is going to be relying on in giving their testimony. Now, it doesn't mean that they relied on the treatise in forming their expert opinion before they came on the stand necessarily. It doesn't mean that they relied on it in writing their report. It could have been. That's a common way that it's tested. However, a learned treatise could also come in or portions of it, I should say, could come in if it can be shown during the examination of the expert, hey, this is a treatise that is accepted in your field, right? This is something that even though you didn't already come in saying, hey, I relied on this, I can, as the attorney, demonstrate that you are accepting the principles of this textbook, let's say, as to be correct, as to be something that would be informative in your field, right? That's the idea. So there's not a particular standard as far as what the publication is, but you're looking for something, a manual, a textbook, an article, something that's been written that is authoritative in that person's field, right? And there's an actual definition of what a treatise is, but that's kind of how we want to think about it for MBE. So how does this work, right? We can take portions of that learned treatise and we can introduce them through the witness, right? So either the witness could read a portion of it, the attorney could cite a portion of it and put it to the witness, and the witness could give their opinion on that portion, right, on the validity of that. The point, though, is that the jury's not actually going to get the treatise, the textbook, the article itself to then look at later in the jury room, do their own analysis on. No, all we're saying is that we can take a specific sentence, a specific portion, whatever, a specific statement out of this treatise. Again, it's something that's being said out of court. We don't have the person who wrote the book live there, subject to cross-examination. So thus, it's hearsay, right? It's an out-of-court statement. But if we want to use it for its truth, if we want to say that what it says in the textbook is actually true, if that's how the textbook says that the human knee is constructed, and we want to be able to talk about it and say that no, that really is how the knee works, then we have to have it come in through the learned treatise exception. And again, what are we looking at? Portions of it can be read into evidence. Portions of it can be read into evidence, and they're introduced that way through the expert to the jury. So that's learned treatise. Again, pretty straightforward. We want to see that the expert is relying on it. If it's something that the expert is not relying on, if it's something, so go back to my first example. If I want to ask the expert about something in a particular textbook, and I want to, as the attorney, try to put that question to them, if the expert says, no, that I don't rely on that, no one in my field would rely on that, I'm not going to speak to that, I can't speak to that, then we're not going to satisfy the learned treatise exception, right? So it would have to be something that the expert is relying on either directly or is accepting as kind of valid governing in their discipline, right? Otherwise, it's not going to qualify. But if it does qualify, the biggest way this is tested is when the attorney looks to introduce the learned treatise in the question, and then they also want the jury to get a physical copy of it. They want to distribute the paragraph that they're going to read from to the jury. And that's what you have to be on the lookout for, that the jury's not actually going to physically be able to receive any of this evidence. They can hear it. They can hear it come from the expert, and in the process of the examination, they can see it and hear it that way, but they're not going to actually physically receive it into evidence. And so that's the learned treatise exception, and that's that one. Two other ones just to quickly be on the lookout for. There is something called ancient documents. So just to be aware, if we have a document that's more than 20 years old and authenticated, then that the contents of that document could come in via the ancient documents exception, just one to look out for. And then there's also this thing that we call the catch-all rule. And essentially, this is where if we have a statement, and this is not very commonly tested, but if we have a statement that is not fitting one of these exceptions, but it is trustworthy, material, and in the interests of justice, we should admit it, or it's in the interests of justice that it be admitted, then the law has created this catch-all hearsay carve-out that allows us to, we don't have to continue to create unlimited different classes of hearsay exceptions, right? Because we've created kind of this list, and we're going to say, okay, if it doesn't fit in one of these categories, and it probably will, so please don't take away from this, oh, well, I can just choose this hearsay, this catch-all thing if it's, if I don't recognize one. This is usually the incorrect answer. Usually on an MBE question, this is going to be a wrong answer. But the one time that it's going to be a correct answer is when we know for sure that it's a hearsay statement, and we also know for sure that it doesn't fit one of the exceptions. If we get an answer choice like, well, it would be admissible if the judge determines that it's trustworthy material and in the interest of justice, it should be admitted. Something like that, right? We have to have that whole criteria there, and if we have that, then we can invoke this catch-all exception to the hearsay rule. Okay, so what I recommend now is to pause your hearsay studying based on what I've outlined so far. We're not done in terms of talking about hearsay exceptions and all the other components of this. But what we've talked about thus far right now are the true hearsay exceptions. What we've talked about are hearsay exceptions, and another thing that I'll say about them is what I've talked about so far, we haven't mentioned anything about, and it doesn't matter about, witness availability or unavailability. So in these, what we've talked about so far, right, present sense impression, statement of then existing mental, emotional, physical state, right, all the way through the business records, public records, everything we've talked about so far, all of that stuff is going to be treated by those rules which are hearsay exceptions, right? Those, if they're coming in, if the statement, whatever is coming in, it's coming in via a hearsay exception, and it doesn't matter if the person who said it is available to come to court or not. It doesn't matter if the declarant is alive, dead, if we can find them, can't find them, if they're going to use a privilege to not testify. None of that stuff. It's going to matter in something else that we're going to talk about. None of that stuff matters in what we've talked about so far. And it's really, really critically important that we learn how to keep the hearsay exceptions, what we've talked about, which don't require any availability, unavailability. We keep that separate from this small list of hearsay exceptions I'm going to talk about in the next segment, where it is going to matter whether or not the person is available. And we have to keep those separate from this other thing that we're going to talk about in a little bit, which is the non-hearsay, right? Which is going to be things like admissions, right? Things like, a statement of one of the parties. And so we'll get into that. The point is that when we classify these as answer choices, we must be precise. Otherwise, we're going to get the wrong answer, even if we know what it is that we're talking about, right? Like, we know it's going to be admissible, but we're not sure if it's admissible as a hearsay exception or admissible as non-hearsay. Well, those are two different answers, right? One's answer choice A and one's answer choice D on a multiple choice test. And so we must know which one is which, because there is no partial credit for that. So with that being said, let's take a quick pause, recap what you have learned, what we have learned, gone over thus far with the hearsay exceptions. In the next video, we're going to dive into a separate set. They're still hearsay exceptions, but they are the hearsay exceptions where the unavailability of the declarant is a critical element. So hopefully you are available for that one.